Thank you, Madam Chair Lady, and a good morning to all, to the Minister and her support staff. Madam Chair Lady, through you, I would like to respond to what I understood was the question or the comment from the Central Bank of Curaçao and St. Maarten regarding an answer given to my question. What kind of legalities? My question had to do with the fact that if in the headline agreement and or the addendum, the possibility for St. Maarten to be safeguarded against any potential legalities, any legalities, other third parties challenging these agreements in which St. Maarten is party. So let me make it clear, that's what I want to clarify. Those kind of legalities, I can't pinpoint this person will come with that legal matter against St. Maarten, Curaçao, and the Central Bank, any legalities. This matter has been also, from the words of the Minister, under pressure, time pressure and otherwise. Do we have the possibility for a year or such to challenge the agreement, one, and to be protected against any challenges coming from third parties to the agreement? Thank you, Madam Chair Lady.
Yes, Minister, you could answer that clarification.
So, MP Wescott's additional question was, can we safeguard St. Maarten from any liabilities litigation that could arise from this three-party agreement? And the answer provided again by the Central Bank, the risk of the countries being held liable by third parties for their role in the resolution of ENNIA seems limited, as the countries are involved only as financiers and at a distance, and the implementation of the resolution is mainly done by the Central Bank. Following question from MP Wescott. Based on the HLA, can Parliament obtain an organizational breakdown of the management structure or organogram of ENNIA? Answer, corporate structure received and submitted confidentially to Parliament. Clarifications. When will the agreements and the obligation be reflected in the budget of the country? Based on the outline agreement and the addendum, the payments will commence in 2027 and will therefore be reflected in the 2027 budget. However, regarding the refinancing agreement, the approval of this addendum will directly impact both the amended 2024 budget and the 2025 budget by reducing our interest expenses. Consequently, a nota van wijziging amendment note will be made to reallocate the savings in interest to another budget line in the 2024 budget. Regarding profits and dividends to be paid by Central Bank, and stated that the last time dividends were paid in 2022, was this of 2022 or in 2022? MP Wescott asked this question because previous information indicated that the last time St. Maarten received payment from the Central Bank was in 2019. So did we also receive payment in 2022, or was this in fact a payment from a prior year paid in 2022? The answer, dividends from Central Bank to St. Maarten and Curaçao are calculated on a yearly basis depending on the financial results of the Central Bank. In 2021, the financial results did not give rise to dividend payments. In 2022, the net profit of the Central Bank was approximately 1.3 million guilders, of which approximately 290,000 guilders is attributed to St. Maarten, as included in the 2022 audited Central Bank financial statements. 3, concerning confidentiality, how will the Central Bank as regulator seek to comply with the confidentiality rules of an enterprise that is receiving public funds? What can the Parliament ask for or not based on this? Based on the HLA, can Parliament obtain an organizational breakdown of the management structure or organogram of ENNIA? Answer, the attached corporate chart has been confidentially submitted to Parliament. With the new structure, ENNIA New will be transparently organized and ownership will be brought under the Management Foundation until ENNIA New can be responsibly brought into private hands. ENNIA New will be subject to supervision by the Central Bank. The different roles are kept strictly separate. All funding runs through the Resolution Fund, and the Resolution Fund has no control in relation to ENNIA New. due to a certification structure that will be put in place. ENNIA New will receive a one-off capital injection against the issue of share certificates. Therefore, ENNIA New cannot rely on funding from public funds. Question 4. Would like to receive the loan refinancing agreement made last year between the Netherlands and Sint Maarten. Answer, refinancing agreement was sent confidentially to Parliament. What is meant, question 5, with Sint Maarten having received the first right to purchase Mullet Bay? Specifically, what does this entail? Answer, in order to strengthen Sint Maarten's ability to purchase Mullet Bay at a market valuation and determine its future, while still delivering maximum proceeds to the creditors of ENNIA, Sint Maarten will be granted a matching right in a Mullet Bay sales process. In brief, this matching right entails the following. If, pursuant to the sales process, Sint Maarten makes a binding offer for Mullet Bay, but is not considered to be the winning bidder, then Sint Maarten shall have an opportunity to improve its offer and match the winning bid. This entails that once a bid is made for Mullet Bay and Sint Maarten submits a bid in the event that there is a higher bid, Sint Maarten will have first priority to purchase at the higher bid. Question 6. Are we to receive a redrafted HLA that will include the addendum, or will the addendum be submitted separately? So, will we receive a new agreement that will include the addendum or the old agreement with the addendum agreement as two separate documents? Answer, the old agreement will remain valid and there will be an additional document to this agreement, which will be the addendum to be signed off by Curaçao, Sint Maarten, and the Central Bank. After it has been approved by the parties, the amendment will be attached to the outline agreement. The outline agreement will remain in force insofar as the addendum does not amend it. Question 7. Have mentioned pre- and post-emergency liabilities based on the regulations. Can a further outline be provided? Answer from the Central Bank. The distinction between pre- and post-emergency regulation obligations depend on whether an obligation has accrued on the date the emergency regulation became effective on ENNIA, dated July 4th, 2018. Post-emergency regulation liabilities include 1, all rights and liabilities of former ECL arising from new policies effective as of July 4, 2018, and 2, rights and liabilities of former ECL accrued as of July 4, 2018, and accrued from policies affected before the 4th of July, 2018, whether or not the policies in question were subsequently renewed, including premiums paid as of 4th of July, 2018, and the returns accrued thereon. Pre-emergency regulation liabilities include the rights and liabilities of former ECL arising prior to the emergency regulation. All rights and liabilities of former ECL, including the return on premiums paid before the 4th of July, 2018, other than post-emergency regulation liabilities. Question 8. Referring to the review after 15 years based on Article 7.4, in answer to my question regarding an escape clause, does this agreement require that the monetary union remain intact for the duration of the agreement? Answer from the Central Bank. The outline agreement is not dependent on the monetary union between Curaçao and Sint Maarten remaining intact. Question 9. Regarding the motion passed by Parliament of Curaçao on promoting the sale of ENNIA New, is Central Bank pursuing this motion and actively pursuing the sale of Mullet Bay? Answer, the Managing Board of Sun Resorts is working on the best scenario for Mullet Bay in the interest of all stakeholders, including the policyholders of ENNIA. Central Bank, in its role under the emergency regulation, will continue to evaluate the best way forward for Mullet Bay in light of the goal of the resolution, which is to reach the best outcome for all creditors of ENNIA, including its policyholders. Question 10. Getting back on Mullet Bay, based on what plan has the Central Bank offered a part of Mullet Bay for sale? Does the plan on what the Central Bank is offering Mullet Bay or parts thereof for sale include the beach, and to what extent? Answer, the part of Mullet Bay that currently has been offered for sale is not located next to the beach. Question 11, the central bank on behalf of Sun Resorts had asked about a building permit that was given. Was the building permit on or off the beach? Answer provided, the location of contested building permit was next to the beach. Minister referenced 230 million guilders as the verdict for the courts of appeal. Is that the sum thus far? Answer, the Joint Court of Justice of Aruba, Curacao, St. Maarten, and of Bonaire, St. Eustatius, and Saba recently confirmed in an interim judgment liability for an amount of at least 230 million guilders, and the recovery proceedings are still pending. In that same judgment, the court appointed an expert to further investigate the historical value of Mullet Bay in order to rule on substantial claims relating to, amongst others, dividend payments based on an excessive value on Mullet Bay. It is noted that this is only an interlocutory judgment, and it is expected that a higher amount of damages will be awarded in the final judgment. Question 12. Minister indicated that a cash flow overview is presented to Parliament confidentially. Has it already been submitted, or is it that it will be presented to Parliament? Answer, the cash flow attached to the initial outline agreement was shared with Parliament confidentially on July 18, 2024. The updated cash flow overview comparing the initial agreement to the addendum was also sent to Parliament confidentially alongside the addendum. And finally, question 13, why is the agreement for the refinancing of the COVID loans confidential? The agreement has been shared with Parliament confidentially in accordance with the National Ordinance on Public Access to Government Information. I move on to questions by former MP Jacobs. Related to time to find a new solution, I understood that the minister stated that the central bank misled the government of St. Maarten with the calculations that has been made. Please confirm that this is what was said and clarify in what way was the government misled by the Central Bank of St. Maarten. My answer, Madam Chair, I did not state that the Central Bank misled the government. What I did state, and in my opinion remains, is that the initial signed outline agreement was not in the best interest of St. Maarten. It is important to emphasize that it is the responsibility of the countries to ask all necessary questions, receive clear answers, and fully understand the financial implications to ensure that they are aware of what they are committing the country to. This is not a simple agreement, which is why I took the time to thoroughly understand it. By continuously asking questions and receiving answers, it became evident that St. Maarten was paying for way more than just its own policyholders. Data on policyholders was shared with her. Is this new information that is now becoming available? Answer, confidential information from individuals cannot be shared with Parliament. However, it behooves me that this data was not requested previously while in government and during negotiations. Question 3. Since the majority of the advisors are still with the minister and in the cabinet, what exactly is brought forward in terms of changes? There is one advisor in my cabinet who was previously involved with the ENNIA negotiations and remains within my cabinet. Please note that he is a legal advisor, and this agreement involves both legal and financial aspects. The major changes in the addendum are primarily of a financial nature, resulting in a savings of, need I remind you, 37 million guilders. While some may say 37 million guilders over 30 years is nothing, I say it's more than zero. Question 4. Clarification whether as to what risk the current agreement contains, that is now resolved within the addendum. What is being averted and how? I presented the addendum on September 6, 2024, whereby I stated the main matters included in the addendum are as follows. Total savings of 37 million guilders for St. Maarten due to 5 million guilders not covering BES and Suriname, 15 million guilders savings by not covering the operational expenses, 14 million guilders savings by reduction in expenses and hence a